Welcome to this special conversation with the Trade and Industry Minister. He is K.T. Hammond. As you may well know, in the last few days, in fact, just over a week, there have been significant conversation around one legislative instrument he's attempting to lay in Parliament for it to mature. And this is a very crucial one for him. It is the Restriction of Importation of Selected Strategic Products Regulations 2023. That is proposing to limit the importation of some 22 products into the country. There's been a fair bit of controversy around this, and tonight we're going to talk to him, ask him a few hard questions about it, so that we can understand a bit more why this is even necessary at this time. My guest tonight, live on the Joy News channel, but also live pretty shortly on Joy 99.7 FM. You can catch the repeat play on PM Express at 9 p.m. Later tonight, is K.T. Hammond. You've heard him argue on this particular subject in Parliament. He is my guest right now. Thank you, Mr. Hammond, for your time here on Joy News and on Joy 99.7 FM. Why the need to introduce this regulation?
Yes, okay. Evans, I came to this office in about, was that April? Yeah, April. But immediately I came here, I discovered that at a point in time, our cabinet had been concerned about the extent of the import bills of this country. And indeed, I had set up a little a committee of about 4 or so ministers, chaired by Minister of Trade, to see about how the country could go about reducing the import bills of the country. Obviously, not much had been done, not even by the committee before the previous minister left, and as I said, not much had been done. But I picked it up from there. We looked at the figures. What was outstanding was the fact that we realized that year in, year out, Ghana was expending considerable sums of our foreign exchange on the importation of some of these items that we've labeled at selected strategic products. Of course, topping the bill will be cars, and particularly cars. But rice was not conspicuous by its absence at all. I think it ranked at second or about third on top there. We looked at the figures. It was quite a huge. The total import bill for the country, I think in 2021, was about $13.6 billion. Now, out of that, it's a list which is not. This is not the entire gamut of the items on the import list that we have been concerned about. There have been about 50 items on the list. And this alone constituted about 34% or so of the entire imports of the country. Fast forward to last year, was another close to about $12 billion imports into the country, and some of these basic items. Straight from the pandemic and all the crisis, everybody seems to be aware in the country. We thought that something strategic had to be done, something fundamental had to take place. We can't just continue doing the old things and expect to get any different results from what had been going on. So the thinking was that, look, the MPP government in coming to government, taking over the reign of power, had said that we intend to transform the economy. We're going to transform the economy on the back of industrialization. we're going to develop our economy, we're going to move away from the Gettysburg, the economy that hitherto we've all been used to transform it. How do we transform it? You don't transform the economy on the back of massive import of almost everything into the country. There has to be import substitution.
But the key question is this the approach to deliver that? Where you restrict strategic products?
That's one of the approaches, yes. So it's a really two-pronged approach. One is to ensure retention, conservation of the foreign reserve itself. Look at the figures that I've given you, billions, 12 billion, 13 billion, and it's been consistent over the years to conserve some of the money. And then in the process, making sure that you undertake local production on a massive scale. I mean, if you are able to balance this right, of course, at the back of it all is making sure that you don't create any shortfalls in the country. So you make sure that there is the monitoring of what we are importing, but at the same time keeping an eye on what is it that you consume at home and what you produce. In fact, a question was put to me the other day, maybe it was a rhetorical question. It was this, that if these countries from whom we import all these items kept on importing, they wouldn't be producing for anybody to import, or countries like Ghana to import. So we thought it was a real option, really to achieve two options, two goals with the option that we have chosen.
What goals?
One, conservation, to reserve quite a bit of our money. You can't put year in, year out that kind of amount into imports. That's one. So foreign exchange reserves is conserved. And then you come back to what I've just told you, industrialization, the development of economy, I mean, creating the local conditions for us to be able to produce and be self-sufficient.
But we haven't done that second bit. That second bit, you put in the cart before the horse here, are you not? Because we don't have the local capacity in the 22 items that you've listed. But you're going to place restrictions. How do we meet that shortfall? So
that is why I would want us to emphasize, clearly underline the point. Let's be careful about the language that we're using here. It's a restriction, it's not a ban. It's not a ban. A few people have been bandying the word about you're banning, we are banning. We are not banning. Indeed, we cannot even do that. We are constrained by the World Trade Organization rules. Not to venture into any of those things. You cannot place restrictions under those regulations, which will make it difficult for other countries to. But
what you're seeking to do is what under the World Trade Organization's rules they call quantitative restrictions. And explicitly, generally forbidding under Article 11. Of the General Agreement of Tariffs and Trade, which is exactly what you're doing.
So you look at Article 12. Article 12 mandates exactly what we're doing. I mean, that's why my whole argument has been pivoted. The fulcrum of it has been about the, the foreign exchange issue, the balance of payment issues.
Article 12, an exception
Article 12
under the quantitative restriction.
Exception under 12. So 12 allows, if the issue is geared towards boosting the country's foreign exchange reserves.
But the rules say if you intend to do that, you must notify the WTO. Have you done so?
Why? We're taking them in stages. We're taking them in stages. We are consistently making the point. We are not banning anything. We are mandated by the rules. We are allowed by the rules to conserve our reserves. I mean, the WTO would ultimately be informed about the processes that we have put in place. We are not banning anything. We are saying that we are restricting by a certain procedure. And procedure is what, if you look at the documentation, you would notice by some sort of import regulations. You see, there's also another part of it that I think hasn't been properly considered. And this is the fact of that's all and feeds into the foreign exchange, the country's coffers issues that I have raised. There are people who import into the country and they declare whatever value there is, all right. They pay whatever there is initially to pay. I am told that following from that, there has been considerable difficulties in tracking all the VATs and the sale, income that should be paid to government and all of that. By now attempting to institute what we are trying to do, obviously this will become quite transparent, because you would declare how much is it that you want to import. We know the figures. You will come back subsequently to want to import again. We would then want to know from you what happened the last time. Now, if you know the figures, obviously GRA will then have access to the books, and then, of course, there will be determination of whether this has been paid, this hasn't been paid or not. There is
paying the right duties is what you're stressing.
To make sure that, the country is not being fleeced in a circumstance that people have been prone to do it. So that, again, also goes to conserve our reserves and, of course, create openness in the system.
Let's talk about the second objective for doing this, which is to, in essence, empower local production.
Yes,
right?
Yes.
Do you admit then, if that is your objective, that
yes.
this particular piece of legislation places the cart before the horse?
Well, I don't know. You keep saying that. Well, let me understand. Why do you say that?
Because
yes.
if you restrict,
yes.
and you don't have enough local production,
well, you see,
then you're going to create a big challenge.
Maybe you're not focusing on this. I've said it so many times. We are not banning.
No, restricting.
We're restricting,
yes.
but we're restricting to the extent that we don't create famine in the country.
How do you propose to do that?
Well, exactly. So you see the committee that has been put together: Agriculture Ministry, Ministry. How many of them? You got a copy of this?
You have Ministry. You have the Ministry of Agriculture. You have the Finance Ministry. You have the GRA. You have.
The food and whatever, what called FDA.
Yes,
they are all there. Go to the page. They are all there.
Including the associations like AGI.
All of them. And so there is this committee that meets and monitors food production in the country. So it's not a simple question of sitting down one afternoon and determine that you can get a certificate or permit or not. No. The ministry is responsible, particularly Agric. There has been quite a lot of liaison between our ministry and Agric Ministry before we came out with this. We thought through. If in the end, the committee through the Agric Ministry tells us that there's a deficit, the deficit between production and consumption in the country is this much, so this much has to be imported, it will be allowed through. It's as simple as that.
So what you're saying is you would allow imports,
yes,
so far as it doesn't create shortage locally?
Absolutely. And of course, so far as also doesn't flood the system. So to the extent that there won't be starvation in the country, we would ensure that the right quantity is allowed into the country. What we would not do, and repeatedly I'm making this point, is to simply get up and arbitrarily suggest that, well, we restricted the import of this, we have restricted. You might well say that the word restriction is a misnomer, and you might be right in saying that, because it doesn't seem to me that right from the word go, we're going to restrict to the extent that you may be tempted to equate restriction to banning, but that won't be entirely accurate. We will be restricting, not in the context of banning, but restricting in the context of keeping an eye on it and making sure that at the same time the production at home is beginning to match our consumption. At a point when there is equilibrium somewhere, then the system will be looking at whether there's a need to continue with the importation of.
But considering, if you look at rice, the big ones, you mentioned them, the big ones. Sure. Considering that as we speak, 2020, the last data that's available.
Sure. $220-something million.
Exactly, coming in. But in terms of the metric tons that we were consuming, some 1.4 million metric tons of that as of 2020. Yes. If you look at what we're producing locally, it's 622,000.
Yes.
There's a huge gap there. Yeah. That needs to be bridged.
Yes.
I put it to you that the restrictions won't solve this particular problem. Even if you restrict and say we still produce 2022, until you have government policies that empowers local producers to grow the production over time, you are going to have the challenge.
I understand that. No, there won't be a challenge. I understand that. Again, if your argument is still revolving on the fact that you suspect that we are banning, then we'll get into this conundrum.
But you're restricting.
But if you see, that's what I'm saying here.
So in other words, in a more realistic question will be, on day one of
this,
you would have to restrict the importation of rice, say, for example.
Day one of this, I may not
allow 622,000 metric tons to be produced locally.
No.
And so you can't import anything more than that difference. That's what you're proposing.
That is the difference.
That's what you're proposing.
But I was going to put it the other way around. Maybe we would have arrived at the same destination. But I was going to say that maybe, as you said, day one, which is from today or from the maturity of the LI, we won't be restricting anything at all. If it's to
the law says within 3 months, people can apply to you.
No, they apply. Of course, yes. The physical application would be undertaken. But whether by so doing we stop bringing in anything altogether is another matter. Yes, they would apply for the purpose of getting a 20 million metric tons, 40 million metric tons. I would have looked at the figures. The committee would have looked at the figures. They would have presented me with the data. And looking at it, I would have thought that, well, how much is needed? 100 and whatever tons, yes, it can be imported. Nothing would have been lost.
Yeah, but that is rice where the data is available.
We're keeping a good eye on the data. Let me tell you about this. We have been particularly concerned about rice because it's all basically the staple of the country. So we got companies like the guys that you met here just before you came in, Olam. They had come to explain to me the installed capacity. Consistently over the last so many months, we've been talking to Zoomlion, you know them, just one group of companies. In fact, they had promised us that if we had been able to put through the mechanism into operation, the mechanism, by this December, they will be producing so much to augment whatever it's already produced in the country. So imports could be to be restricted. But of course, we had to do a roadshow for purpose of consultation to get all those stakeholders involved for us to measure the barometer of the country before we undertake this process.
So I was talking about the other items on the list.
Yes.
You have stuff like fish.
Well, start from the top.
Well, I mean, we've talked about rice. We've talked about rice already.
A few more there.
You have poultry, for example.
Yes.
And if you speak to the Poultry Farmers Association, they say we don't even produce up to 1% of what the demand locally.
That's not my information. They don't tell me that they don't produce 1%.
I mean,
it is true. The local production
according to the recommendation, let me quote the exact figures. So 400,000 metric tons is the demand locally.
That's right.
We are currently producing locally 57,000. To be very specific, 57,870.
Yes.
Metric tons of poultry.
Yes.
That's a huge gap. You're talking about a significant gap. In fact, what we import still leaves a gap. We're not importing all that we need for the local market already.
Well, we're not importing all. We're assuming that we produce something.
So my point is, how does your policy address this huge gap without creating a shortage that shoots price up and creates inflation?
At the risk of repeating myself, let me take you back. And that's what consistently I'm saying, that we are not banning. So in the particular instance of poultry, we may simply have to regulate, observe, evaluate what's going on, and then decide on how we go forward. It's the case that if we were importing, say, 1,000 metric million, whatever, of poultry, we probably would keep on producing to the extent that we are not bridging the gap. But if the system that we put in place, the help that we intend to give to poultry farmers, and all the mechanisms that we put in place, if it is able to catch up, we hope that going forward, we'll be able to bridge the gap, and that the import into the country will be reduced. Looking at it, if having put all the factors together, there's still the risk that putting restricting in the terms of not allowing anybody to bring poultry into the country would affect the country. We won't. We're going to rationalize. It's not. Insanity is not going to break loose because we're trying to restrict. We would monitor as much as we can and make sure that we balance the system. We want to encourage local farmers. We want to encourage local poultry. But at the same time, I've also told you, also keeping our eyes on our foreign reserves. But that can never be at the expense of the ability of people to feed themselves in the country.
The architecture of the bill, as I've read, creates room for corruption, for rent-seeking behavior, does it not? This committee that answers only to you. In fact, you can decide, even when they recommend to you, whether to grant a permit or not. That creates room for corruption. You disagree?
I am tempted to use so many phrases when it comes to some of this, but I'll contain myself. It's just annoying, you know. It's just annoying when it's suggested that. I don't think you belong to the camp of some of the other colleagues who see nothing good in this and suspect that it's geared towards lining the pockets of people who obviously are not accountable. It's silly. Let them take the necessary few minutes and read through the documentation. The committee consists of ABC. I think about my last count was about 13 or so. Now, 13, you have the deputy minister of my ministry here, who will be the chairperson, and then there will be somebody representative from our Greek ministry.
Let me go to them for the sake of those who are watching. By the way, you're also live now on Joy 99.7 FM. This would have been top story time, but we are speaking to the Trade and Industry Minister, Katie Hammond, on the back of the controversy that has erupted on his proposals to bring in a legislative instrument that will restrict selected strategic products in terms of its imports. And we're having a conversation with him also on Joy, on the Joy News channel. Later tonight, you can catch the full interview on PM Express from 9 p.m. But to the point, though, you have the Ministry of Trade and Industry represented, and the individual there must not be anybody below the rank of a deputy minister. So I guess your deputy minister will represent you, and he will chair. Yes. You have the Ministry of Food and Agriculture also there, somebody not below the rank of a director. You have the Ministry of Finance. You have the Ministry of Employment, Labour Relations, Ministry of Interior. You have the Bank of Ghana, Custom Division of the GRA represented, the Food and Drugs Authority. The Ghana International Trade Commission is represented, and then the AGI and the Ghana National Chamber of Commerce and Industry. Your point about this?
So it's a very powerful committee. Now, where it leaves room for corruption, I'm not so clear. Now, after this committee has decided on whether there is a need to import some more products or to retain whatever it is as it is, anyone who is unhappy with the outcome of the committee's deliberation has the right to appeal to the minister. I'm not so sure, no, before appeals to the minister. At this stage, the minister, then the committee recommends to the minister. They recommend it. It isn't the minister who at his whim and caprice decide on what to do. There is a recommendation by the committee.
But you decide whether to take the recommendation or not.
We'll go to the next bit. The minister then decides. You are right. I would have thought that if this powerful committee is decided that a permit or a license should be granted, a minister will see no reason to differ from those.
But that power is given to
I have no doubt at all. Let's go to the check on the minister. Now, when the minister decides not to grant, that is the fear of my colleagues articulated the other day on the floor of Parliament. The minister, Katie Hammond, will decide because there are NDCs involved. They were very clear. NDC involved looking at their faces and whatever. That is how much they fell below the standards to describe this matter. Would decide that they're not going to grant it. The minister wasn't going to grant it. All right. What they haven't read is that when the minister refuses to grant your license, to cancel your license, all the negatives that they outlined, you have the right then to appeal back to the minister to review his exercise.
Judge and jury.
It's all over the place.
Section 18 says appeal to you. The same person who have rejected it maybe a few months back.
Let's get there. You show me where the Section 18 is. So the minister is asked to review his decision. Is there in the court, Supreme Court, when they make a decision, the Supreme Court has jurisdiction within which they are asked to review
their own decision. But they add a few more judges to it.
But in
your case, it comes to you, the same person who rejected that permit.
Let me deal with it. So when I refuse, following a review, you then have a recourse to the law court. Is there, black and white. So the minister, be it Katie Hammond, be it whoever, has not absolute control unbridled control on the outcome of this. Go to that particular section.
But within the act, though,
yes,
you are the final authority here.
No, I am not.
You are the appellate body.
Where is the appellate?
You are the only person.
Go to the appellate. Tell me where is that.
Let's go to section 18. Let me go to section 18, which I quoted earlier.
What does it say?
Section 18 says,
yes,
1, a person who is aggrieved,
yes,
by the refusal of the minister, not only to grant the permit, but also after the renewal has been turned down, may within 14 days after the receipt of the notification of the decision of the minister apply to the minister in writing for a review of the decision of the minister. The minister shall, within 14 days after receipt of an application for a review of the decision of the minister, A, take a decision on the application, and B, communicate the decision in writing to the aggrieved person. It ends there.
It doesn't end there.
Well, tell me if there's been an amendment to this.
It doesn't end there. Is that what you have?
That's what I have.
Well, you see, that's why you should be careful.
When was this review?
When you get in this, you don't get in this. 3. Have you seen the 3?
Talk to me about 3, because I don't have it in the version I have.
Well, you probably can read better. Look at the 3. You know, so give me your document then. I'll give you this one.
This is my document.
You got your nose. You see, journalists, you should be very careful. Well, you know, where do you hijack this from?
Well, this is from Parliament.
I don't know whether this
is from Parliament. This is the same parliamentary document.
Well, I don't know about that.
3 says, a person dissatisfied with the decision of the minister under sub-regulation 2 may seek redress in court. My question to you really is, this is before Parliament, and they got them from Parliament. When was this?
But be careful, there's nothing before Parliament.
No, of course. I mean, of course, I know, because, you know, but then the pre-lane conversations have happened. So your colleagues have it, and that's where I got this one. When was this clause added?
I'm not sure. It was always there. It was always there. I'm not sure why. I tell you what, I don't know where you got this from.
But it's a fair question. When was this?
No, it's always been there. It was always, look at the other one. Two, I just told you about the one that they thought they were interested in, later on shifted their interest, the cement one.
We'll come to the cement one.
It's clearly there, so I don't know where
my substantive question remains.
It's always been there.
My substantive question remains. Yes. You're actually saying that, again, within the confines of the act, you are the final authority. Of course, the courts then have to now decide whether you're right or not.
Administratively, somebody would have to be the authority to make a decision. In this case, it's double-layered. The committee and then to the minister. You're not happy with the minister's decision, go to court.
But why do you want to create that avenue for the minister to have that level of discretion, which, obviously, from our history, leaves room for you to be manipulated?
That's a spoiled that.
Remember that. Beyond you, there'll be ministers beyond you who have to enforce this.
Why are you looking at Katie Hammond? Okay, let's talk about the minister. But why
this is institutional.
No, absolutely. But why do you think that this is an embodiment of corruption?
You may be a saint.
No.
You may be a saint, but somebody may occupy your seat tomorrow.
Claim to be a saint.
No, tell me, somebody may occupy your seat tomorrow.
And that person cannot lay claim to infallibility. But nobody is going to access this and be able to thereby corrupt themselves. I mean, what do you make of the reference to the court? I mean, I don't understand.
But in this country, it goes without saying
that
the ultimate decision makers, Mr. Ketia, you know you're a lawyer, so you know, even if Parliament decides, the ultimate deciders are always the court. So actually this clause is just stating the obvious. That in all circumstances, if you're dissatisfied with any decision of any entity, you can go to court. You have recourse to court.
But
so the fact that you stated it here,
if you're conscious of the fact that the addition adds nothing to it, then why were you hammering on the fact that, well, it isn't on your document and that creates avenue for corruption?
Now that I've seen the updated document, I'm asking a fundamental question.
It was always there, so, but notwithstanding this, that what?
My question to you is, including this fact here, it's stating the obvious.
So
even if you didn't include it,
so we can ignore that one. You can ignore that. Someone could have gone to court. Judicial review, I'm conscious by that. So what is the point? That doesn't add anything.
My point is to have this checks and balances built into this. Why don't you have an appellate body other than yourself?
To do what?
To adjudicate over your decision.
What does it say? So what the judicial?
It makes it more transparent.
You're conflating the issue. I don't think you're getting it right. What does the appellate body do? What does it do? The appellate body. What does it do?
It will decide whether or not they can review your own decision.
And then they're going to court. What does it do?
Well, of course, I'm saying that whether you include this or not, even at that appellate body case, when you're not part of it, that person still has a cause to court.
So I don't get it.
It makes the process more transparent. When at the level of the committee,
Which committee?
If you can create another committee. In fact, what I've been suggesting, let Parliament be the appellate body.
I told you about that. Don't pretend that you knew that when I told you about that.
The MP said that last week.
No, the MPs, I didn't quite understand what it was. It didn't make sense to me. My leader, Oseche Bonsu, said to me, was it possible to rope in Parliament at this stage? How do you do that? This is the administrative structure. Get Parliament to do what? This is an airline. I don't quite understand how this should be done. Fortunately, back to the Attorney General, and he says he doesn't understand that.
The Attorney General has given his opinion on this already.
Attorney General, that's why we've got to be very careful. People shouldn't assume that you're a minister, you sit in your office, sit around your desk, and you have the right to do whatever you want to do. Nelson has been to Attorney General's office more than many times.
What's his view on this?
Attorney General is signed his imprimatur on it before.
So he's okayed it before
he's okay on it. And then when we went to Parliament the other day, and the suggestion was that we should still make some additions, we still went back to the Attorney General, and the particular one that you're talking about, the constitutional whatever I told you about, Attorney General didn't understand. He had no comprehension. It didn't quite make sense.
As in coming back to Parliament.
For what? But Evans, let's get this matter very clear. You seem to be so agitated about the matter of an appeal. An appeal process is the equivalent of a review, except that they are different processes. But when a decision is made by a decision maker, an administrative decision maker, whether it was put there or... Indeed, let me share this with you. Maybe you are right. My view was that it did not make any sense adding that particular to it. Of course, that particular...
The three.
Yeah, the three. It didn't make any sense.
So you agree with me then?
On that point, I do. But I was told that for the comfort of those who will be reading and who are not all lawyers, because...
I'm not a lawyer. I saw through it.
I made a fun about it. But lawyers, you want money. So live it like that. Your clients, they will come to you. If the decision they don't like, they'll come to you. But it was thought that so that there is no doubt about anything, put it there. You're talking about an appeal. That is appeal to the legal process out of the jurisdiction of this room, out of the bosom of the Ministry of Trade and Industry. The judicial process takes over. If it is appeal, what kind of appeal? Appeal to the court or appeal by a set of a panel? I don't understand.
So, Ms. Amma, my only question to you is, I want to stop using the word appeal and use the word that your own regulation uses, which is review.
That's right.
I'm saying within the confines of this ministry, because you are champion in this,
yes.
You're saying that it will be more transparent when you institute, when somebody wants to review your initial decision, to go to another body other than yourself.
What is the judicial review, my body?
Because the principle in court, when you want to review, is that's why they have the appeals court. Even at the Supreme Court level, they add 2 or 3 more judges to the panel. Just so to create a sense that the same individuals and the same people who will be adjudicated over the review.
You're losing balance on this matter.
I'm just asking. In this case, though,
yes.
You say for the first time,
yes,
I won't accept your permit. I reject it.
Okay.
Then that same person, if they want to review, must come back.
But you know what they do? I may have missed out something fundamental. That's why we have the principles of judicial review. I'm not going to lecture you on judicial review principles. No, I wouldn't. But that is why you go back to the person who took the decision, draw the attention to the irrationality of the decision that they have made, the illegality of the decision they have made, the unfairness in terms of the procedural impropriety of the decision that they have made, which they may not have been conscious of. So you draw the attention to these matters, they sit down for the purpose of review. If they are not happy with it, it used to be, and I tell you, in the civil courts, it used to be Order 42 of the Civil Procedure Act of the High Court, CI 47. Order 42, review by the judge who took the decision had the power to review their own decision. It's now been taken away from.
But he's a judge, you are a politician.
But that is the matter.
There's a fundamental difference.
But so,
you are a politician.
How can I accept that completely? That is why I've made my decision amenable to the court, the highest decision-making process, body, not politically, but the judiciary, is the High Court. And when we say that you can seek review, administrative decision, straight to the High Court. How best could it be? you put in any appellate processes and whatever, there is still what it could be a tribunal or whatever. It's still an inferior body. I've given you the authority, the power to go to the highest judicial body, the process of judicial decision making in the country, the High Court. What is the complaint? They will strike down my decision. If in the end it is thought that my decision is tainted with illegality, irrationality, procedural unfairness, they will strike my decision down. Evans, I don't know. I don't plead guilty to this particular argument.
I want to take you back to the floor of Parliament.
Yes.
Your leader in the House, Mr. Bonsu, was on his feet in open Parliament and said, well, Mr. Hammond should make amendments based on the meetings you had and return on Monday with some of the...
Which would have been today.
Which would have been today. Yes. And then I got also on my show speaking to Carlos Ahinkra, who gave me a bit more specifics. Like you met with a minority and agreed that you're going to, this particular contentious clause, you're going to include this parliamentary appellate body.
Well, that
you actually agreed to do so. True? Well, I just want to check.
No, listen, I've already explained. My view was I didn't make my sense.
Okay.
I mean, it wasn't. I mean, number one, let's get it right. It wasn't the view of the committee. I've told you, Article 11, Clause 7 of the Constitution does not give anybody the right to preview my document. I mean, when I say
you just lay and you count the days.
It's as simple as that. You see, look at Article 106 of the Constitution. Procedure for enacting law, absolutely different. The framers of the Constitution, in their wisdom, did two things. One, legislative instrument. This is how it's going to be done. Proper legislation, bills, which would then lead into substantive acts. You have to go through these processes, lay before the committee, the amendments on this. But on a particular matter of LIs, orders, and those regulations, very straightforward. Order Clause 7 of Article 11 says, you, the promoter of it, invariably the minister, lay it in Parliament. When it's presented, gazette it. When it's gazetted, 21 days, maturity into law. If Parliament doesn't want it, the subsidiary committee of Parliament doesn't want it, after 21, well, not after 21, before the 21 days, they come back and then tell Parliament that we don't like it, and then by a majority of 2/3 of all members of Parliament annul it.
So what happened to...
But that's the whole point. That was the base of the argument, if you were listening the other day, that I was raising. And that this whole concept of a pre-laying and whatever, how did it come about? I don't understand. In deference to my friends, to the speaker, Aban Babin wasn't forcing that I go and see anybody because he knew the clear in his mind. He just referred them to it, knowing what it is. What are you guys saying? I previously wasn't Aban, was one of the deputy speakers. Oh, I agreed that I was going to sit down with my colleagues. But in that meeting, I tell you today, they added bits and pieces.
When you say they, who are you referring to?
Committee, the subsidiary committee of legislative, the subsidiary committee,
which is traditionally chaired by the minority,
and this time chaired by, this Parliament chaired by my good friend Dr. Dominic Aine. Yeah, he chaired it. And all of them. Mm-hmm. I mean, all the members were there. The proposition has absolutely nothing to do with this constitutional thing. I didn't understand.
What did they propose?
I will tell you, he is a senior lawyer. He understands some of this. How could he possibly have thought about a minister coming back to Parliament on matters like this to engage the processes of Parliament? What does it mean? So their business, their concern was some of the items that were put on there. Another issue was the justification for this whole bill. This whole, I'm accusing people for using the wrong terminology now. I'm also
you nearly use the word ban.
Bill. No, the bill. It's not a bill. It's an ally.
It's an ally. Okay.
Yeah, it's bill. It's as I said,
of course.
for the laws. So for the legislative, those laws that eventually become act of Parliament. Yeah. So they made. They were absolutely insignificant. The conclusion was that, subject to this suggestions they have made, they were quite happy. You
agreed to include the suggestions in this document?
Yes, they have all been included. They were so infinitesimal, were absolutely nothing. They were quite happy.
So let's bullet them. So what was going to happen now?
Following from there, can we lay suggestions from some of the front benches, minority front bench. Oh, our ranking, the chairman will obviously be there. Chairman hasn't reported to us. I don't understand why hasn't reported to you. Then I got to know that he's reported to them.
You mean Dominic Ayine?
Yes.
Hasn't reported?
That was the allegation, that he hadn't reported to the leadership.
The outcome of the meeting which you just talked about.
Yeah, that's right. It turned out not to be true. He had reported to them. Then what do we do? Okay, let's...
But was that outcome a consensus position that was going to be communicated?
As far as I'm concerned, within the committee was absolutely consensus.
So you're saying that the NDC chair side and the MPP chair side all agreed at the committee level
they completely
to lay?
Yeah, sure, they lay.
With the change being reviews will return to Parliament.
I can read to you. I mean,
please, I'd love to. I'd love to.
You know, let's
this is a show of facts, by the way, as you have seen. And I would love for you to read what the actual text is, based on the agreement that you reached.
Can I have my phone?
Please, sir. Please do. And by the way, you're still live here on the Joy News channel. You are live on Joy 99.7 FM. This is a very important matter, and I really want to get the minister to get to the heart of it.
I appreciate
and also give us the facts as he has it, so that we can interrogate that. And so he's referencing the consensus agreement that was reached.
I quite understand
with both the majority and
what I'm going to do, but I think it's important so that this duplicity on the part of some people should abate. It's completely unnecessary for the processes that we go through there. I think people should be transparent enough, should be men enough to accept the reality of what happens over there. I mean, it isn't in the domain, it isn't in the province of any particular individual to insist that I would not allow a particular process that is legitimately mandated by the Constitution to go on to undergo proper processes in the court, in the House. It's not your gift. It's not your prerogative. It is. Look, in a boxing ring, we have the rules. Courts have the rules. Parliament have the rules. The whole country have their superior rules in the form of the Constitution. We should be following the Constitution, and not because it doesn't suit our political gastronomy, we decide that we are going to be a stumbling block. We're not going to agree to this. I'll get there. I mean,
I will allow you time to look for that.
It's coming. It's not.
Yes, it'll allow time. I'm going to take a quick break. Yes. When I return, we'll refer to that consensus position Katie Hammond says was reached with the minority at the committee level, which was supposed to be presented to the House for consideration, that then will pave way for the laying. And then we'll interrogate what that really was. Stay with us. And thank you very much for staying with us. This is live on the Joy News channel. It's also live on Joy 99.7 FM. In the last few days, as you may have noticed in Parliament, there's one subject that is dividing the House. It's a subject that we're talking about tonight here on Joy 99.7 FM and also on the Joy News channel. It is the subject of the restrictions that the Minister for Trade and Industry is seeking to place on some 22 strategic products, which is causing a bit of a consternation in the House, but also, as you've heard from many interest groups, today a petition has been submitted to Parliament by some of the parties aggrieved at this, asking for this to be withdrawn completely. The minority side is clear that they will not support this in any form. AGI is on the committee that will be granting the permits for those who may be seeking to import into this country. They obviously are for it, and they want room for the minister to lay for it to mature. This is a major subject, a subject of national interest, and so we're spending some time with the trade minister who is proposing this to go to the House, and he's with me. Before we went for the break, you had stated that you had a meeting with the Subsidiary Legislation Committee, at which meeting you said that there was a consensus position reached, subject to the inclusion of some amendments.
Yes.
I wanted the specifics of these amendments and what the committee said.
I'll give you, dated 22nd of November 2023, and I would normally not be divulging this, but because you see, constitutionally, there's nothing like this. There can't be any such report. The only report on these items is when I have laid the document and it's been referred to the committee. And as I've told you, if by two-thirds majority the committee reports back and says that they don't want it, the committee wasn't happy, and they are recommending to the House to annul it, then the House by two-thirds majority can annul it. Now, we hadn't even gotten there. So this pre-laying exercise, it's a convention. It's something that has been put in place. And indeed, it was primarily for election CIs, not for this sort of thing. But in any event, I obliged because my colleagues were saying that they want to have a look at it and all that. I was quite happy to let them have a look at it. This is 22nd of December. And this is
22nd of November.
Forgive me, yeah. 22nd of November. Now, it talks about reference to the discussions that we previously had, because all the discussions, and then talks about the two legislations we have told you about. This is one, and then the cement one, and then the meeting. They asked for the rationale, stated the rationale here. The Honorable Minister gave two reasons underlying the proposed instrument. The first reason given was that some of the items, products listed in the schedule to the draft regulation demand the overlay of substantial foreign exchange to import, and therefore a significant cause of the balance of payment problems of the country. The idea is that to ensure that their importation is restricted with a view to reducing their negative impact on the country's balance of payment. The measure provided for in the proposed regulations will streamline and rationalize the import bill of the country to improve balance of payment aimed at reducing the trade deficit and promoting favorable economic stabilization in accordance with Section 12 and Paragraph A. In accordance with Section 12, and paragraph, but it's Section 12A of Section 13, paragraph, in accordance with Section 12A and Section 13 of the Export and Import Acts 1995, Act 503. The second reason provided by the Honorable Minister was that some of the selected products will be restricted to protect the local industries that produce such products. According to the Minister, Ghana is overly dependent on important products of which the local industry has the capacity to produce, and this is affecting grossly the confidence of investors who are willing to invest in these selected products. These regulations seek to limit the importation of the selected strategic products and provide a platform for local industries to produce, save, to meet the demands of the population and to compete favorably with their trading partners. Members of the committee made suggestions for amendments to the substantive clauses of the regulations generally. In respect of the affected products, it was decided that cement be deleted from the list of restricted imports and in its place diapers be inserted. The explanation provided was that cement industry is proposed to be comprehensively regulated under the draft cement industry, the one that I told you about. Furthermore, the ministry proposed that frozen cuts of offals be inserted as item 23 of the on the list. Frozen cuts, okay. Frozen cuts, okay. And then they have another one we call offals, and then he says that we explain that offals are categorized differently from item 2, which is the guts, bladders, and the stomach of animals. Good. Well, the committee, listen to this. The committee demanded that data be provided to it regarding the basis of the minister's justification for the restrictions on the basis that imports are having a negative impact on the country's balance of payments. At the end of the deliberation, the committee concluded that subject to the proposed amendment, the minister could proceed with the laying of the instrument. And then we go to the other one, the cement regulations. It goes on, makes similar points, and then goes on to say that the minister gave examples of the recent development in the country whereby a number of cement manufacturing factories have had to be closed down as a result of evidence that they were producing and selling substandard cements. Members made numerous proposals for the amendment, which were accepted by the ministry. At the end of the deliberations, the committee took the view that the draft regulations conformed to the powers granted to the minister under the Ghana Standards Authority Act and does not violate the Constitution and may be laid subject to the amendments. Conclusions generally. The committee had no reason to believe that the two draft regulations were not within the ambit of the parameters set under Article 11 Clause 7 of the Constitution and the Standing Orders of Parliament.
And your point is?
My point is this: it was on the strength of this that I proceeded to lay the document the day after.
But we've heard the minority leader say that they oppose.
That's what I call duplicity. This is the committee that I was compelled, contrary to the demands of the regulations, demands of the Constitution and the Standing Orders, to go before, to explain myself. And this is the report to the minority leadership. And then they come back to tell me that, well, they don't know about it and whatever.
This was on the 22nd of November.
This is the 22nd.
On Friday, yes, was there another meeting where further proposals were made?
So following this, wasn't any other with the committee. The committee following this was done, expert, they done their work. So the leadership of the minority side, kind of in a whispering conversation said that, well, I can't tell you everything. We are colleagues, you know, so a lot of things that you get upset when in the end of the day you think they're stabbing you in the back, and then you get.
Have you been stabbed in the back?
Well, I think so.
How?
I think. Well, I mean, you can understand from what I've just been speaking.
So the minority have stabbed you in the back?
Yes, particularly based on what I've just read to you. I mean, I wasn't going to go anywhere before any pre-laying committee, because I've made a point. It's not mandated by any constitution. Subsequent to this,
on Friday morning, I understand there was another meeting.
But there wasn't a meeting with a committee.
Okay.
It was a meeting among the leadership.
The leadership.
Yeah, listen, my leader, H.M. Sabunsu, took it up on himself to have a discussion with the minority leadership and a few of them. They called me behind the lobbies, the division, you know the division when we go through this. And what is it that we can do? What is it? Make proposition. What is it? I am bound to lay this thing. It's not a matter that I sat at my desk and then I produced this sort of list. If you read my documentation, you will see the road show. You would see the extent of consultation.
We'll come to that.
Yeah, sure.
So in these informal conversations, what concessions did you make on Friday?
Whatever they wanted to include in there.
What did they
were not significant. Indeed, ultimately, the one that they said we should put in was that to make sure the constitutional thing we talked about, that there must be some recourse.
That the review comes to Parliament for a final decision.
No. It was this. I can phrase it for you. It was. Firstly, it was put in some amorphous and cacophonous state that I didn't understand myself. So I helped. And I said, well, if you want a reference to the committee of Parliament, could it not be in this shape? That anyone who was aggrieved by the decision of the minister could then petition Parliament. That's what I suggested.
And will Parliament have the final decision if the Parliament takes a decision contrary to your decision?
Well, that is what it was suggested ultimately. That Parliament, I didn't quite understand that at this level. I mean, when the LI, the law, this decision regulation were made on the back of a substantive act that has been through Parliament. The minister could do A, B, C, D. The minister has prepared a document in which he has made a reference or made provisions for a redress in the High Court. Parliament doesn't sit in adjudicative capacity.
But you agree to that?
Well, ultimately, because they were all over the place, but I made the point, I insisted that it didn't make sense.
But you agreed to
it? Well, I agreed to that.
But
where is
it in the document?
You see, the government lawyer, senior most government lawyer, is the Attorney General. And so, I can show you again, if you give me 1 second, is there in the writing? Have you seen that it's in the manuscript? Is it? No, that is, there's something that has, no, you can't see your eyes.
And at this moment, we're looking for the Attorney General.
Yeah, no, it's not Attorney General. I was looking at the writing, the insertion on this document. There is the insertion on this document. You know, no, that's not it.
But to the point, what are you looking for there?
So one of these, it's an insertion in the manuscript, the actual phraseology, what was wanted. What was then demanded between to the leadership, my side and then the other side.
So the two leadership agreed, which is what you said.
That ultimately there must be recourse to Parliament. Yeah, Parliament, for whatever reason they thought.
Which you agreed.
I agreed. You see, I keep saying that I agreed, but I said you didn't make sense. I knew it wasn't going to fly with the Attorney General.
You answered the question. So what happened after your agreement?
So I took it because they said the Attorney General should look at it.
And what
I wasn't going to just put anything the Attorney General hadn't seen. I took it to the Attorney General with a lawyer from this office, and the Attorney General's office was no way, Jose, it doesn't work like that. I was vindicated.
So it's not going to find expression in the document.
So the final one that I've given you,
that's what I've just read.
Yes, what you read.
It ends with the courts.
It ends with the court, which is very sensible. Which is sensible.
But that directly will pitch you, especially when you had agreed with the minority majority. That pitches us directly against the minority.
Evans, again. I have given you a precondition. I told you that I agreed, but I knew it didn't make sense. But there were some people who were pressurizing and pushing that it should be in there. I'm telling you, you will put in there. The Attorney General will reject it.
Yeah, but Attorney General rejection, this makes it a due killer, you know?
No, it doesn't.
Why doesn't it?
Because let's go back to basis. No one has a role in the laying of this document. Parliament is not happy with it. They marshal to test majority and then annul it. Since what I've read to you. Attorney General, former Deputy Attorney General, now the chairman of the subsidiary committee, makes it pretty clear. Your argument, perfect, within the law. What is that
it's not only the minority side that agreed it should include this. Chairman Sabounsi, you only agree too.
No, listen to this. Listen to this. Again, Chairman Sabounsi was with me. Both of us thought it didn't make sense.
But on the floor, he said you will return this morning.
No, we'll return, and that, again, listen to me. When we are browbeaten by our guys, our friends over there, we want to make this. We get into all sorts of rapprochement, we get into all sorts of compromises everywhere. He is the leader of the house. He wants government business to take to proceed without necessary hindrances. So if it takes so much compromise to get government business going, so be it. So after so much hee-ho, ballyho about this matter, his view was that, okay, if this meets the demands of our colleagues over there, so be it. Particularly the phrase that whoever was not happy could then petition Parliament. Now that preserved the position of the minister in terms of review functions, and then it also preserved the ability of the person to seek redress in the court. Because it was in this, it's not in mandatory, it was in this permissive tone. You may. So if you chose to go to Parliament for review, for petition to petition, you could. I mean, you could still have recourse to the court.
Parliament.
Yeah, petition to the Parliament and then to court for the redress. Either way, you could do it that way. Attorney General's view was that no.
So it's not going to happen.
That's going to happen. What it is that a provision is there, and you rightly stated it didn't even have to be there, as I originally thought. It shouldn't have to be there. It was ultimately agreed that for everybody's sanity, everybody's to avoid all this headache, let's put it there for clarity. So we put it in there. That is substantive. Listen, when the Parliament eventually is accused, well, not eventually, sometimes is accused of unconstitutional order, you seek redress in the court. From this very beginning, I am making provision for you to go to court. I don't see what your worry, and for that matter, I don't see what our colleagues' worry would have been. The argument was that how can you take a decision like this without coming to Parliament? I didn't understand it. I don't think you understand it. Parliament is not an adjudicative body. Parliament is a legislative body which is respected for that matter. Some petitions are sent to Parliament, ultimately is referred to some committees. This is not the function of Parliament. That was my view. Some people agreed.
Well,
and then
the reality remains, you don't have the support of the minority on this.
You would never have, again, I wouldn't tell you.
And they've made it very clear that
we don't need
they will shoot this down. They'll do everything possible to make sure this
within the law. Within the law. You see.
Yeah, you said within the law, but you haven't laid it still.
No, have you seen something that has been developing, some recent practice become the new normal? This particular Parliament, what I've seen is that people don't like A, B, C, D, and then they are fighting. I mean, throwing things left, right, and center. I would have thought that would operate within the law. I mean, a civilized institution like this Parliament, we should operate within the law.
The minorities representing the interests of the people.
That you are falling into their trap, Evans. You recall that one of them had the guts. I mean, I think with respect to whoever, I've forgotten whoever, had, let me be calm and let me controlled. But this was his phrase. We represent the good people of Ghana. I think you heard my response. Well, if the suggestion was that we on this side represent the bad people of whichever country, I almost got into a diplomatic tangle because I was going to supply the name of the country, and then somehow, God help me, I checked myself. You see, how could they possibly make that sort of argument? that we represent the good people of Ghana, and so we don't like this. But so I represent the bad people.
Mr. Hammond,
what's your constituency?
Well, my constituency is Pumkatamanso.
So I represent the bad people of Pumkatamanso. Yeah,
no, but Mr. Hammond, the minority, they are not alone in objecting this. Today, there's a petition that has been submitted to the House by at least 6 groups asking for it to be rejected. Civil society groups have raised similar concerns, which I put to you. The rent-seeking behavior that this creates. So there is a significant number of people out there, including interested parties, stakeholders, who side with the minority, that this is inimical to our economic interests and only creates room for politicians to feed fat.
Listen, Mr. Interviewer, you are entitled ultimately to your rules. There's not much anybody can argue on this point. The facts are stuck. We're all looking at the same fact. I presented the facts. I mean, the committee said that we should justify our suggestion that 13.6 billion, 11 billion dollars. It has a negative influence.
I mean, the Saskatchewan Trade Vulnerability Report is replete with facts.
Who can make such a statement? That's so much. Let me make my point. So it's obvious. It goes without argument that it is so much. It causes so much damage, so much negative effect on the economy that somehow somebody has to look at it. Now, but if on the back of that it is suggested that because the NDCs and the people doing it, it is the MPPs doing it.
But that's not the suggestion.
Now, what is the suggestion?
I mean, the petition having submitted today are not political
where is
folks.
The corruption? I've told you the minister is recommended to that you qualify or you don't qualify, or you should be allowed to import or you shouldn't be allowed. There's a recommendation to the minister. Minister says, I agree to the recommendation. All right, if the minister agrees to the recommendation, does it foster corruption?
Well, if the minister then, as we've seen, and this is
don't fight about. If the minister says, you are interviewing me, I'm supposed to ask questions, answer questions, but you also can answer one or two.
No, I'm not supposed to.
So if the minister agrees to the import suggestion that the recommendation of the committee that you can, Evans and Co., you can have so many whatever to import. You wouldn't call that corruption.
What if he doesn't agree?
But we're going to go there. Well, let's deal with the first one.
Because you acknowledge I asked the question, so what if he doesn't agree?
But you haven't answered my one question. But I take it that you accept that if it is agreed Evans and Co can have it, there's no corruption.
I don't think so. And because
it is your worry
whether you agree,
if it is not
whether you agree or you don't.
Okay.
We simply do not trust politicians to make these decisions.
Unfortunately,
with the
decisions have to be made by politicians. I mean, the nature of the system is like that somebody has to make a decision.
And that is why we put in place sufficient checks.
I'm so happy about that.
To check discretion.
Absolutely.
Where are the sufficient checks
I'm coming to tell you.
To check your discretion here?
Absolutely. You ever sitting there today, you see me sweating, I'm answering your questions, you in the comfort of your chair, putting all these questions to me. That is why you would not have the responsibility of bringing about this document. I would have to. I'm a politician. But I'll come back to it. Yes. I'll answer it. So that's why I have the responsibility of doing it. So somehow somebody would have to do it. Then you talk about
what are the sufficient checks
and you talk about
to check your discretion,
my friend,
in this matter?
Your article 296 of the Constitution talks about all these discretionary whatever. These discretionary issues are all embedded in the concept of judicial review, which has been articulated in this document. Evans.
I want to quote you another aspect of your own act.
Yes.
It says, in terms of what you consider before you grant a permit for an import, the company is required to provide a list of documents. One is the particulars of the principal officers, directors, and partners of the company or firm. People smell an elephant here.
Well, they can smell. It's not, what you want is bigger than the elephant. They can smell something bigger than the elephant. Again, listen, if the concept is
in other words, you may want to know the people to find out their politics, whether they support the elephant or not. But you see why this is an issue. But why do you need principal of the directors and partners before you grant them a permit?
Does it give you the political colors? Your office, I mean, we are in this country and we knew about... people who had committed to so much loans from other countries, and I don't want to remind you guys, the young ones may not remember, but you are big enough to remember those things. Problems about addresses and this. It's been too all three fundamental, very important landmark decisions in this country, the Supreme Court, about addresses, about the place of the addresses of companies.
But this is not about places. It's about principal officers, directors, partners,
absolutely,
the company and firm.
Yeah. Yeah.
Why do you need that to grant a permit to import a product?
Well, that's very important. Okay. So we're trying to make sure that this whole thing is Ghanaian-centered. Ghanaian-centered is, what do you call it? What is the other bit that local content kind of thing? You know, so I asked you about your principal place of trading. Yeah, what is wrong with that?
No, you don't have any. That's not my question.
Let's take them one after
because
the other. Yours is that the owners, isn't it? Who are the?
You asked for digital address, which is what you said, place, etc.
The auditor, Registrar General, is now asking for all this information in any company.
But that's not my question.
Well, that is not your question. But I'm giving you instances of the application, the content of the question you asked me. That will lead to corruption. How would that be? The fact that I asked who is this person and it is Richard, Evans and Co. Yeah. Yes, Evans. My God, ask Evans. Don't give him.
Yeah, but
that's your fear.
But my question is, you haven't answered my question respectfully.
Yeah, go on.
Why is it relevant to ask for the principal officers, directors, and partners of the company before you grant the company
why
license?
Why don't you want to know the individuals you are dealing with?
But
you don't want to deal with faceless people. You want to deal with human beings, real characters, real human beings. But you see, ultimately, you ask a very fundamental question. Where are the checks and balances?
Yes.
I've told you the checks and balances that you are worried about are all in there. Ultimately, your fear is that because it is Richard Mensah and Co., the stakeholders are Richard Barnes, Richard this and Junior and this and this and somebody will decide not to give
that. That is what our history says. Politicians.
Well, I don't know about that. I don't know which history you're looking at. I read history, Form 5 and 6 form, and I've done politics all these years and the law. I don't know which history you're talking about. But in any event, we come back to the check and balances that you rightly put in.
And I asked the question,
check and balances is
apart from the
judicial review.
You say ultimately to the court. So
what else can we do?
So that's your check.
Decided that I don't like your head, and that's really I like your head. You know, your head is just like, well, it's not as bold as mine. But because I don't like your head, I won't give you. You go to court, and it's a complete non sequitur. By way of making a decision. I mean, it cannot follow that because of your face, your head, or whatever. So much negative decision will be there. The court will have no hesitation in striking it down.
The timing of this. I mean, you're going into an election year. I mean, people don't read a lot into this.
Why are you? You're going into election, so what?
This obviously some have raised a concern. That it is placed at this time, year before an election, because it could actually potentially become an avenue for raising funds.
Let's be reasonable. I'll stop pandering to this foolishness. I'm not going to answer any more of these questions. I mean, I've told you what it's all about. There's the court, and everybody thinks that anyone has that mentality that is going to line the pockets of whoever. Which form is it going to manifest itself? How is it going to line itself up? You are afraid that I won't give you because you are Evans Mensah. On the other hand, the flip side, you are afraid that how do I become corrupt? How do I get corrupted? By giving you the license or by not giving you the license?
I mean, let's talk about consultation.
Yes.
What consultations went into
this? I'm all over the place.
What's the evidence of this? Because I've heard food and beverages head say he wasn't consulted at all.
All right, have you seen it? Secret and cabinet and all of that. You know, listen, a government, and I've made this point, you know, there are certain things that we do consultations. I mean, you suggest at one point that the president
consult beyond cabinet, obviously.
Yes, beyond cabinet. That's not the point I'm making about cabinet consulted or cabinet not consulted. But I'm saying that it's all demand that NDC was asking me that all my notes and whatever, eventually, not the committee, eventually the leadership was asking me, all my notes and everything, I should let them see. Doesn't make a lot of sense. Where did you hear that? But anyway, you were asking about the
who you consulted.
Yeah, I'm going to give you the list, and then you will see what is it that was done. And then check with all of them. Listen to this. After the objectives, then stakeholders invited to various consultations included Ghana Revenue Authority, Ghana Immigration Services, the Ministry of our own representatives, Food and Drugs Authority, the Standards Authority, Ministry of Food and Agriculture, Ghana Union of Traders Association, Association of Ghana Industries, Importers and Exporters Associations of Ghana, Rice Farmers and Producers, Poultry Farmers and Association, Ghana International, but I think you've gone through this list, Institute of Statistical, Social and Economic Research, and then private sector stakeholders. Now, interestingly, recommendations from the stakeholder engagements. After the consultations, the following recommendations were received from the stakeholders. The list of the selected products should be expanded to include the following: baby diapers, sanitary pads, electrical cables and conductors, copper, aluminium, roofing sheets, steel pipes.
And you say importers and exporters were part of the making that
recommendation.
You mentioned them.
All of this.
And they all agreed to actually expand.
And expand for the expansion.
And as we speak, you say that you are replacing cement with parts.
Because there's a separate document for...
Okay.
Cement,
based on the recommendations, that take out the cement and then include it, and bring in sanitary diapers.
Whatever, yeah, sure.
Okay. So those are the people you consulted.
Yes.
And so when you heard on radio, the Food and Beverages, association say they were not part of it.
Funny enough, let me just check. Food and Beverages.
Yes.
That's why I wanted that document. Are you almost done?
Yeah. Well, Food and Beverages and Nguta, the Ghana Union Traders Association.
They've actually been included in the committee. They are now members of the committee.
Now?
Yes.
So there's a new architecture.
I told you, you rushed, and then you got hold of.
So you've included Nguta now? This is the new one. This is the new one. Let me just go to the.
I just gave you.
So this is the new document. Yes. I'm gonna go. You said you've included Nguta now.
Just check and let's see.
Okay. Let's see if that fact is here. So Trade Ministry, Ministry of Responsible.
The bottom and who are there?
Oh. Yep. Okay. So let me go through that now. There's a new document, updated one. It says before we had Food and Drugs Authority.
Is there?
Now you've added an expert in international trade nominated by minister.
Okay.
You've added the Association of Ghana Industries. They were there before. You've added the Ghana National Chamber of Commerce. They were there before. The Ghana Union of Traders Association.
Is that the Nguta?
Nominated by the Ghana Union of Traders Association.
That's Nguta.
Yeah, that's Nguta.
Nguta is there.
Then you also have added the Food and Beverages Association of Ghana, nominated by the Food and Beverage Association of Ghana.
Evan, don't rush about some of these things. You get it wrong. Wait for the final product. They don't listen to all the hype all over the place.
So you've got a Food and Beverage Association and Nguta.
Our time.
But I asked the question again. When was this amendment made? Today?
No.
Over the weekend?
After we met with our colleagues. This was some of the suggestions.
Friday?
This was suggestions
Friday. So this is literally over the weekend.
No, 22nd.
22nd.
Yeah, the very first meeting. This was some
22nd was a Wednesday.
Yeah.
So this must have been between Thursday and Friday.
I think, Thursday, Wednesday or so, following the meeting between the consultation among the leadership, some of these groups were added. But I think the sticking one which they said they wanted. But you see, I think that's actually not the case. Because if it was, we agreed that we're going to insert that. Why should they still insist on not allowing us to do this?
So as I speak,
yes.
The freight forwarders, importers and exporters, food and beverages, Chamber of they petition Parliament on this.
They petition, but it's okay. I mean, let you and I agree that in matters of this nature, you're going to get 100% happiness.
And you say that, and you say now you've included them as they are the decision makers.
Decision makers, yeah.
Okay, but it comes back to the point. Their decision is subject to your final say.
I'm tired on that particular point.
And having said that, where do you go from here? Because you still need this laid.
Yeah, it will be late.
When?
I'll try tomorrow and see.
You'll try. That's an admission that you may fail.
No. Well, you see, ultimately, I'm not the speaker. I'm not the leader. My leader, who is the leader of the House, and that's government business, would... You see the order. There must be another. It's a procedure. There must be another paper. This item would have to be on the way we indicated here. And then on the particular day, if it is tomorrow, he would have to get up and say to the Speaker, Mr. Speaker, we now want to present this document. The Minister is here to present the document. I mean, that's how it's done. I, at this stage, have no control. I sit at the back there. I watch the leadership. I watch my leader, who then tells the speaker that this is what he wants done. But this is the point that consistently I've been making. At this point, it should be over. Because nobody should have control if we're going by the dictates of the Constitution. It says when the minister, whoever is presenting, is ready and is presenting it, he presents it. Full stop. So it should be a matter of natural development. When the speaker, the leader tells the speaker that we're going to do this, he has to say, okay, is the minister here? Okay, you want to lay your distance? Just go ahead.
So you try again tomorrow.
Well, yeah, you know, so, but when your colleagues on the, your friends on the other side stand up and they jump to the, shout from the rooftop, we wouldn't agree, we wouldn't agree. We wouldn't agree on what constitutional or statutory basis? Evans.
So, today, though, I mean, what's your direct response to the petition that the food and beverages and others have submitted?
I haven't seen it.
Have you seen it? Would you sit with them at least?
Because I think we sat with them already. But if we have to, you know. But I think the consolation in all of this, I don't quite get the drift. Is it that they want the situation, the status quo ante to be as it is?
Their point is that this is a policy that, of course, everybody agrees. However, the implementation...
no, you say everybody agrees.
Fundamentally, everybody wants this economy structurally changed fundamentally.
This is a way of implementing.
I use the word fundamental change.
Yeah.
This is not a fundamental change. The argument is that fundamentally, you have to empower locals, create a policy that enables local production before you do this. That's a fundamental change in the economy.
It goes without saying that these are the things that we intend to do. That, ultimately, what will be the point? In the simple, we do know where we are starting from, the starting blocks. We do know that there is such deficits in the system. We're saying that we want to restrict. But you only put in restriction in the place without any effort to bump up your production. How are you going to balance the system?
So where's the complementary policy to encourage that?
But you see, this is the thing. What do you think we have been doing here? What do you think I've been doing? I guess sometime I leave this place about 11 o'clock. You think we don't have any policies? 1D, 1F, and all those things going on.
It hasn't yielded the results.
Well, it hasn't
yielded the results that you yourself had spelled out for us.
No.
You're not meeting, you're not fulfilling your potential, the full potential
of full potential cannot be realized overnight. But
therein lies the strength of the argument.
That what?
Why don't you wait to see substantial results there, improve the local production before you implement
a distance of so many thousands of miles, you know what? You start with the little steps. You know, these are little steps.
But bottom line, you will engage them.
If we haven't already engaged them, why not?
But they have a petition, so definitely they are aggrieved.
They are aggrieved to the extent that what? They're saying that...
They are aggrieved because they believe it's not addressing the fundamental challenge that they face.
I think if I'm not... for all these hours, maybe I hadn't tried previously, but I think after all these hours, the amount of talking we've done, somebody should get it now. The remit of the ministry is simply to put together the fundamentals for us to be able to help our local producers. In so doing, we're also saying that we do intend to help our payment of balance issues so that we don't expend all our monies on importation. In the meanwhile, because we are aware that we don't have a full installed capacity, we are going to put in place all the measures. Companies, the rice producing companies that we have met with, the poultry farmers that we have met with, the proposals that we have put in place, how are we going to ramp up our production? I'm telling you, at a point in time, but we've done all of that at a point in time. Zoomlion assured us that by this December, if everything was in place, they were going to make sure that production of rice alone had gone up significantly. In the process, we spent all this time going on the process of a consultation. And then here we are, somebody suggesting that we haven't consulted enough. My deputies have been all over the country. We have so many consultations in the conference room. And we thought we had put together a good case, at least to those who were present.
As it stands, you're not going to get this passed before December. I mean, it's going to go into next year.
Well, 21 days, if we don't have 21
you don't have 21 days.
But you see, again, it wasn't the point. When you kept on saying that at the time, I thought your point was that, well, Christmas and all of that.
Yeah. No, did you want to mature before Christmas?
No, if it matures before Christmas, it will still not affect imports or products for Christmas. any importer who is desirous of bringing in anything for the purpose of Christmas will longer have put the orders and will be receiving them anyway. And the thing about it is that there's also a clause, there's transitional clause in there. Those who have already imported their stuff and whatever, they have 3 months.
3 months
and
to
then
write to you.
Further extension and whatever to get this in. But I think going forward, let me look into the camera and address those the naysayers and those who are not so clear. Listen, those who are watching and those who are listening to me, let's get this fundamental issue right. It is not an attempt to line Katie Hammond's pocket with anything. It is not an attempt to line the MPP's government's coffers with anything. It's nothing to do with going into an election next year. It is simply an attempt to revive the economy, which has experienced some rather difficult headways. I don't think it is acceptable for a country to expend as much as the figures that I've quoted. 2021, we spent about $13.6 billion to import all these products. Last year, we did close to the same figure to import these products into the country. Meanwhile, the producers in this country, some of whom, just before Richard and your guys came here, somebody had come to even talk about flour. Apparently, the installed capacity of flour is more than consumption, yet we are importing flour. But so this is the reason. We want to, as I said, two-pronged measure. Control the imports so that our balance of payment issues could be resolved one way or the other, and then also concentrate on our local production. We'll keep importing. In the end, almost invariably, we will be where we are. And yet we talk about unemployment, we talk about not helping domestic production. We're saying a question is turning up and up again. What is it that you're doing for to make sure that the gap is bridged? People should allow for rational thinking. A ministry, like trade industry, which is charged with the trade and industry development of the country, would be given some credit to appreciate that you would need to bump up your own local production. And if it does not accepted, at least if it's not taken for granted, we are articulating it. That is what we are doing. And from all indications, we may not have successfully achieved what we set out to do. But then again, it is early days yet. 1D, 1F is doing what it can. Private sector production, it's going up. I just indicated Zoomlion, what is the name again? The poultry farmers, the aqua farms, and others, they have all been here. Government I probably wouldn't tell you how much money has gone into this, and quite a lot of monies have gone into helping them to set up. We have what we call the participating financial institutions. Government has paid so much money to these institutions, bank institutions, which have gone to reduce the percentage rate of interest paid by this company. That is part of the, those are part segments of the financial ambience that government is putting in place to make sure that their concerns are resolved. Concerns will be resolved. Ultimately, I think we will get there. You don't start from anywhere and sit up and think that we're always important and not concentrating on our local production will get anywhere. I'm afraid we might not be getting anywhere.
Finally, you also want to touch cement. You have a regulation before the...
Touch cement.
Not want to touch cement.
Touch cement.
Yes. You have a regulation.
That's been laid. Funny enough.
What does that seek to do?
Funny enough, when we went the other day to the 22nd November meeting, my colleagues on the other side said the interest was mostly in the cement one. They wanted to be sure about the cement one. They seem to be fundamentally
what do you want to do with
comfortable with the import substitution bid. And then all of a sudden it turns truncated. The interest is now in that one and not in the cement one.
What do you want to do with the cement
one has been laid. Well, to ensure standards. Look, all the infrastructure in this country, everything is cement. You don't have qualitative cement. You don't have cement production complying with standards. Buildings would collapse. We have sitting here been receiving reports about how shoddy the production methods of some of these companies are becoming. So in the last few weeks, the Director General of Ghana Standards Authority came to me and told me 3 particular companies around the Kumasi, Ashanti region area, Kumasi, Cement, 3 others. Their standards went good, went in conformity with the Ghana standard. They were warned to set up and shape up and get the standards right. They wouldn't do it. I authorized him to close them down until they came to the table and decided that they would conform to our standard. This is what we have here. For now, again, the installed capacity of cement production in this country is so many miles.
You're not limiting the importation of cement, are you?
And this is not about importation of cement.
Indeed,
there's already a document. Funny enough, the NDCs are not complaining, but there is a document here, which I think LIS, which was put in place, legislated during the time of the NDC, restricting. I'm sure it was during the time of the NDC. I think it's 2016 or so. It wasn't us. But there is don't worry about it. If I'm wrong, that's fine. But there is an LI which controls the importation of cement. But this one particularly is about standards. Make sure that there is now no license for anything. Anyone just gets in here and set up a cement factory. It doesn't matter the location, the geographical location, whether it's among population, whatever. They just cite their cement apartment.
And so, to be clear, in the original bill for the restrictions on importation of strategic products, it included cement.
Well, yeah, because we hadn't drawn our attention to the fact that it had.
But following consultation, you have taken that out.
Yes, sure.
So cement will no longer be part of those strategic products that you will limit or restrict its imports.
But I've told you, the concern is with the restriction. There's another one anyway that controls the importation. Listen, I tell you, I mean, again, that is, I will tell you this. It is for the minister in the end to sign. 2-3 months ago, my desk has a document. I'm looking at it, and people were fretting. Jatta Cement. Everybody knows who Jatta Cement is.
Jatta Cement belongs to the brother of John Mahama.
Everybody knows it. People were fretting, literally. What's the problem? Jatta Cement, yes. This is for Ibrahim. Yes, what is the problem? Bring me the documentation. Has he certified this? And that? My
you
signature.
Approve it.
What is the big deal?
Were the people who were fretting? Your own people?
Those who presented the application. All over the place.
These people were fretting. Your own people in your party were fretting that you're going to approve.
You're not listening.
Well, I'm asking for clarification.
Those who presented the document, because of something...
They were not sure you approved.
Well, because of something they had done in the documentation.
What have they done in the documentation?
I will tell you.
Katie Hammond, thank you very much.
I like you.
And that is Katie is the Minister and Industry, answering our questions on the very contentious subject of the regulations that he's seeking to introduce and lay in the House. He says he will try again tomorrow that will place restrictions on the importation of 22 items. As we've just learned, that is going to be expanded now, I believe, to 23?
23.
23. Enjoy the rest of your evening.
Good show.
Thank you.